Let me ask you kind of a political question here, and as honestly as you can answer this. Were you surprised with the appointment of Eric Brown? He's your Democratic opponent. He was already running for Chief Justice. Were you surprised with the appointment of him?
No, I wasn't surprised.
How has that been on the court and the working relationship with the court?
Well, you know, I tell people that I have an opponent, I don't have an enemy. So we work for the people of Ohio. We don't have a choice in who we work with. So, you know, the court's business continues.
Okay. Let's talk about several recent cases if we can. And James and Joe have covered some of these extensively, so I'll have them jump in. But let's put the first one up here. Ohio businesses can now sue people in other states who post defamatory comments about them on the internet. The effects of this could be huge because it makes you accountable potentially for what you write on the web. This is an interesting case, Justice. And you were one of those that thought that that was a good idea. Explain this case a little bit more.
Well, you know, the court doesn't usually go beyond what is written in the opinion for an explanation. We speak through our opinions, and the contents of that opinion, I think, were very clear. There's a connection with the doing business in the state of Ohio. That's always been a hallmark or a justification for being able to include that entity or that person in the courts of Ohio. And that's basically what this case is all about. It's not saying there's a that the issues, the merits of the case are being resolved. It's where that case can be heard. And that's basically the sum and substance of the case.
Gotcha. James.
In the other case that we've written about recently, I think it's on the board right there, that basically employees who don't meet a certain minimum tenure requirement can be dismissed if they take a pregnancy leave. In this case, that was the issue. It's kind of in line with an earlier ruling that the court made that said new mothers can't take an unauthorized break during the day to pump their breasts if they're lactating. Both of those decisions were denounced by certain groups that promote motherhood. Would you say the court is anti-mother as they're characterizing it, or how would you characterize those two rulings?
Well, obviously, you're always going to have some sensational language attached to any opinion that the court writes by individuals or groups that are not pleased with the decision. In this case, it was not a focus on a woman who was pregnant. It was on the policy that was established and articulated and disseminated to all employees. I think Justice Cupp used the phrase that the policy was pregnancy blind. It had very little to do with what the reason was that the employee took off or failed to show for her work. It would have been the same had she had any other condition that would have precluded her from her job duties. So it happened to be a pregnancy issue here, but it was equally applied to men and to women, and the condition was not the trigger.
So as long as there is a, let's say you're a business and you put a 1 year, you have to work for the company for 1 year.
Before you're entitled to the benefits of a leave, yes.
And but with the understanding that that's across the board.
Exactly,
so
and that's what this employment policy was all about, that this is universally applied. And the law requires that you do not discriminate against a woman who is pregnant, but you also do not afford favoritism. The law does not require or advance favoritism. It has to be an equal application, and that's what this case was based upon, and that's what Justice Cupp acknowledged in writing the majority.
One of the things I'm wondering, we know that former Chief Justice Tom Moyer, one of his major issues, he talked a lot about merit selection and trying to bring at least the perception of fairness back to the court. Now that he's gone, do you see yourself taking any lead in that issue or doing anything with that issue? And if not, who do you think on the court might step up and try to deal with that?
Well, it's, first of all, not just an issue for the court. And that's what I think the conference that was put together last fall indicates, that this is a broad-based approach to how we select the judiciary, and we select the judiciary through a constitutional process, and it would require a constitutional amendment. So this is not something that judges or the Supreme Court can, by fiat, determine what they would like to do. So it has to get broad-based support if it's going to be put on the ballot, and then the electorate in Ohio needs to vote on it. I'm a big proponent for let's put it on the ballot. Let's devise a system that is an alternative to what we have, and let's put it before the people and stop all of the, back and forth about whether we should have merit selection or we should have elected process. It's not my opinion nor your opinion that matters. It's what the people of Ohio want, and they ought to be given a chance to weigh in on this.
Let me, if I can, follow up on Joe's question and get a little bit more philosophical on this. If we can, here's actually a quote from Tom Moyer. He said, "The goal is to get money out of the election process for judges. This is the best chance we've had in my 23 years on the bench." That was a quote from late last year. The philosophical argument that he laid was, look, when you put money into judicial campaigns, there's always that, even if it's not factually true, there's always that possibility that it will be viewed at the very least of having some kind of influence on potential cases that come before the high court, the highest court in the state. On a philosophical level, beyond just putting it on the ballot, let me just take it a step further and ask you, on a philosophical level, is it a good idea to remove that potential influence of campaign cash from Supreme Court justices?
Well, I don't think that this is the panacea that most people would suggest that it would be, and I'll give you an example. If we have a merit selection process, chances are it will require a retention election. And a retention election allows for a positive vote for the one candidate that is on the ballot to be retained. In the event there's opposition to that candidate being retained on the ballot, there can be a tremendous flow of dollars to have a campaign waged against that individual or for that individual for retention. So this does not preclude money into a judicial race, either pro or con. It's just a different type of judicial ballot. So it's not, as I said, a cure-all. Now, is it a problem with the races that are currently, what's the problem to raise money for a municipal race, a trial court race, in the common pleas bench, the appellate bench, or the Supreme Court? It is part and parcel of the election process. In the midst of a campaign right now, one of the most difficult things and probably distasteful things that you do as a candidate is worry about fundraising so that you can get your message out to the voters. It's a necessary evil, unfortunately.
Sort of the distasteful part of a campaign for Chief Justice that we can talk about, and maybe part of the reason why Tom Moyer wanted to move away from this type of campaign. A couple accusations, counter-accusations that we want to talk about and put on the table. Chief Justice Eric Brown accused of personally soliciting money for his campaign, and Justice Maureen O'Connor, who's our guest today, accused of endorsing another judicial candidate. We can say on Eric Brown, an audio recording of the Chief Justice has him asking a supporter to attend a $1,000 a plate fundraiser. And then Justice O'Connor, the counter charge against you from the Democratic Party is that you're in violation of a rule prohibiting political endorsement by judges, which I guess, two questions here. What do you feel about the political endorsement and that complaint made against you?
Well, I think that it probably would be best, because this is being investigated according to the rules that apply to justices and candidates for the court, to just let the process take care of it.
Okay. Was there any endorsement that you recall? Was there a political endorsement?
Well, I'm going to let the process take care of it, and I will answer the the inquiries made.
Any comment on the charges from Republicans against the Chief Justice here regarding the $1,000 alleged solicitation for his campaign?
No, it's got to be the same answer. We'll just let the process. That's why it's in place.
One last question on it. Is all of this kind of what Tom Moyer was getting to, that maybe this could be avoided if merit selection, if we had appointment of judges rather than this?
Well, yeah, I think that you certainly wouldn't have the fundraising focus that Eric Brown is subjected to, but you may very well have, some sort of a restriction on judges speaking about one another. I don't know. I don't know.
Okay. James.
Basically, the heart of that complaint that involves you and Justice Lanzinger had to do with remarks made at political dinners and so on.
So it's really a very cordial relationship. Justice Lanziger and I are very good friends, but we do not agree on all topics. Oftentimes, we find ourselves on the opposite sides of a case that's come before the court. What this all emphasizes is that it's judicial philosophy, and it's not your party label, what you are personally as far as a Democrat or a Republican or whatever you're registered, that's left at the door.